present Justice Brianna Young of Torkin, Christine Cusey of BLG, Katie DiTommaso of Steiberg Burlach LLP, and Dr. Stephen Glazer of Hummer River Hospitals as Medical Director of Bariatrics presiding. Justices of the panel, I present to you, speaking on behalf of the appellant, Ms. Armstrong, in today's matter before the court, Alexis MacLachlan and Stephanie Morris, and speaking on behalf of the respondent, Dr. Ward, Charlotte McKenna, and Hiram Sutton. We are here today to determine the outcome on appeal before the court on the matter between Ms. Armstrong and Dr. Ward. Both the appellant and the respondent's counsel will have 30 minutes each in total, 15 minutes each counsel member, to present their arguments to this court, including answering questions from the bench. Appellants will present their arguments first, followed by both respondents, and then a 3-minute rebuttal period will follow if you so choose to use it. I will signal to the court when there is 5 minutes left per speaker. Oh, it flipped, well, that's fun. And 0 when your time has elapsed. Appellants, will you be using your 3-minute rebuttal period today?
Yes, please.
Wonderful, thank you. The court now invites counsel for the appellant to begin.
Justices of the Walker Supreme Moot Court, good morning. As my friend Ella said, my name is Alexis and my co-counsel is Stephanie Morris. We're here today on behalf of the appellant, Ms. Karen Armstrong. As you're aware, this action arises from an injury that Ms. Armstrong sustained during a laparoscopic colectomy performed by the respondent in February of 2010. On this appeal, we urge this court to restore the trial judge's ruling. The reasons for our position are as follows. First, we submit that the trial judge properly formulated the standard of care as one of reasonableness. Second, it was appropriate for the trial judge to consider causation as evidence to inform whether the respondent fell below the standard of care. Third, the plaintiff only has the duty to rule out non-negligent causes raised at trial. And lastly, the appeal court should have reviewed the trial judge's decision for reasonableness instead of correctness. I'll be discussing the issues of the standard of care and causation, whereas Ms. Morris is going to be speaking to you about the duty to rule out non-negligent causes and the appropriate standard of review that the majority should have applied. I'll start by discussing the correct standard of care to be applied to this case before I move on to causation. There are 2 points that I want to address regarding the standard of care. First, the standard articulated by the trial judge was not a standard of perfection. Second, the standard of care did not focus on the goal or the result to be achieved, but rather the steps that the respondent should have taken to meet the requisite standard. Our friends will likely argue that the standard of care set by the trial judge was a standard of perfection, and we respectfully disagree. The trial judge correctly formulated the standard of care based on uniform evidence about what a reasonable and prudent general surgeon would have done and should have done when operating on a benign colon. As we know, the standard of care for a medical practitioner, as articulated in Kritz and Sylvester, is to exercise that degree of care and skill which could reasonably be expected of a normal, prudent practitioner of the same experience and standing. An unfortunate outcome does not constitute proof of negligence. The trial judge instead needs to look at the expert evidence presented at trial and decide what could be expected of a reasonable practitioner in the same circumstances. We submit that this was a case where there was no one, none of the experts, none of the parties even suggested that there were any circumstances in which a surgeon might not be able to maintain a safe distance from the ureter when operating on a benign colon. The respondent testified that he believed he had indeed succeeded in staying at least 5 to 15 centimeters away from the ureter. All of the experts who provided an opinion on the standard of care agreed that to meet the standard while operating on a benign colon, one had to identify and protect the ureter, but also stay at least 2 millimeters away from the ureter while using the ligature. This last step is the one that the respondent failed to take. I mentioned that the appellant's colon was benign because this is relevant to the context in which the trial judge defined the standard of care. The experts testified that it's not difficult to identify and protect the ureter unless the anatomy is obscured when there are risk factors like large pelvic masses, inflammatory disease, radiation therapy, etc. But in the absence of those anatomical obstructions, like in this case, the surgeon should have no issue staying away. It would be unusual to be that close without any pathologies forcing them to be. The respondent agreed that it was an error to use the ligature within 2 millimeters of the ureter, but denied it would be a breach of the standard of care. During cross-examination, he was asked, if you did use the ligature within 2 millimeters of the ureter, if you did it and you still don't know if you did it, that was an error on your part. Do you agree with that? To which he responded, I agree. The respondent's expert, Dr. Hagen, also agreed that there's no risk of injury to the patient's ureter when this procedure is performed properly because the surgeon is centimeters away. In his own words, he said, it's not possible to damage the ureter if you've identified it. Dr. Robinette, also the respondent's expert, was cross-examined on his standard of care report. He agreed with Dr. Hagen that the standard of care was to find the ureter and then stay away from it, far enough away from it so that your instruments don't inadvertently injure it. He agreed that if the respondent inadvertently used the ligature within 2 millimeters of the ureter, that was a breach of the standard of care. That's the respondent's own expert evidence. As such, the crucial step of staying 2 millimeters away from the ureter while using the ligature was not contentious. It was agreed by the experts that a reasonable, prudent general surgeon would do this during this basic surgery, as Dr. Hagen called it, while operating on a benign colon. It was a reasonable step that the respondent should have taken. It's not expecting a general surgeon to meet a standard of perfection. It's just holding him to the standards that the expert said a reasonable surgeon in his position would have met. Let's take a look at another example. Let's say a baseball player holding a baseball bat knows, and other equally qualified baseball players in the same circumstances agree, that if you swing the bat while someone is standing less than 2 feet away from you, you will injure them. Swinging a baseball bat is common. People do it all the time, all over the world. Baseball players agree that it's a known risk that if they swing the bat while people are standing less than 2 feet away, they're likely to injure that person. So it's standard for baseball players to take steps to make sure no one is standing that close before they swing the bat. But there are some conditions under which it's a bit harder for the player to make sure no one's standing that close, like if something comes in between them and the other person. For example, if the weather's bad and snow is obstructing the player's view. Players all agree it's more challenging to make sure nobody's standing there if there's heavy snow coming down. But if the conditions are clear, there's no reason not to be able to make sure that no one is standing that close. If a player nonetheless on a bright, clear, sunny day strikes someone standing within 2 feet, is it reasonable to say that they shouldn't have done so? Yeah, of course, everyone agrees. If there's no risk factors, nothing blocking their view, the baseball player should be able to swing the bat and keep it far enough away from other people so that no one gets injured. That's what the evidence on this case supports, a finding that a reasonable, prudent general surgeon performing a basic surgery in an ideal setting should be able to identify, protect, and avoid direct contact with or close proximity to the ureter while using the ligature. We submit that this is a reasonable standard. It is not a standard of perfection. Furthermore, it's our submission that the trial judge did not set a result-oriented standard of care. An example of a standard that was found to be result-oriented was the one articulated in Filoka and Pinkertons of Canada Limited. In that case, the standard set by the trial judge did not say what it was that Pinkertons was supposed to do to prevent entry into the mine. There were 23 points of entry to the underground, and the trial judge found that Pinkertons did not meet the standard of care because they failed to properly guard the entrances, thereby permitting access to the mine. This standard of care was found by the Supreme Court of Canada to be flawed because it did not actually say what it was that Pinkertons was supposed to do, but failed to. But in this case, we know precisely what it was that the respondent was supposed to do. It's what he thought he actually did, which was stay at least 2 millimeters away from the ureter. So we would argue that the trial judge did not err by setting the standard of care according to the result, but instead it was a reasonable standard that contemplated what the respondent should have done. It's also our position that describing protecting the ureter as a goal, like the majority did, is not helpful. We submit that trying to decide whether staying away from the ureter is a goal or a step muddies the water. Distinguishing between steps and goals in this case is just semantics. For instance, is making sure no one's standing next to you when you swing the baseball bat a goal or a step? Is ensuring that the operation is performed on the proper patient a goal or a step? Is excising the proper organ a goal or a step? Is not burning the ureter with the ligature a goal or a step? If we were to distinguish between steps and goals, we submit that staying away from the ureter should be considered a step that the experts agreed should be taken and that the respondent believed himself capable of taking. When asked if he takes any steps during the actual use of the ligature to protect against injury to the ureter, the respondent replied he would take the step of ensuring you're several centimeters away from the obstruction before deploying the device. I'll now turn to the issue of using causation as circumstantial evidence to inform the standard of care. It's our submission that the trial judge correctly inquired into what happened to cause the appellant's injury before deciding whether what the respondent did fell below the standard of care. As we know, the parties argued conflicting theories about what happened during the procedure to cause the injury. So, before being able to find whether what the respondent did breached the standard of care required of him, the trial judge had to inform that analysis with what the respondent actually did. We submit that the trial judge could not have properly decided whether or not the respondent fell below the standard of care without first examining those theories advanced by the parties about what caused the injury. Other cases from the Ontario Court of Appeal have affirmed that there are situations, like the present, where it's necessary for the trier of fact to take this approach. For example, in Maringalo and Oshawa General Hospital, and Grass and Women's College Hospital, where the Court of Appeal overturned the trial decisions because they failed to examine what happened to cause the injury before deciding whether there was a breach of the standard of care. We submit that this case closely resembles those precedents because causation, or what happened during the procedure to cause the plaintiff's injuries, was a critical trial issue in each and every one of them. Therefore, it's our submission that there was no error committed by the trial judge in this regard.
Counsel, I have a question. So you said it's sometimes allowed, you can assess causation first. How do you know when that's an appropriate situation or not to assess causation before determining the standard of care?
Of course, Justice. So the reason why this was a case where the trial judge had to use circumstantial evidence, as I was alluding to, is because what happened during the surgery was a central issue at trial. Both sides presented evidence suggesting different things had happened during the procedure to cause the injury. So before deciding whether what the respondent did actually fell below the standard of care, the trial judge had to inform that analysis with what the respondent actually did and how the injury was actually caused, or in other words, using circumstantial evidence of causation. As I mentioned, the other decisions from the Ontario Court of Appeal have affirmed that sometimes it's necessary to take this approach. So we submit that because the cause of the injury was a main issue at trial, this approach was appropriate and actually required.
Thank you, counsel.
Thank you. As I mentioned, as such, it's our submission that there was no error committed by the trial judge. Justices, those are my submissions. Thank you. I will now pass it over to Ms. Morris.
Thank you to my co-counsel. I will now address the question, does the appellant have a duty to rule out non-negligent causes? It's our submission that the appellant did not have the duty to rule out all possible non-negligent causes, but rather that the appellant only had to rule out those raised by the respondent at trial or by the evidence. At trial, Ms. Armstrong, as was her duty, established a prima facie case of negligence by providing expert evidence that the most likely cause of the injury was the negligent deployment of the ligature within less than 2 millimeters of the ureter on a balance of probabilities. Once this case was made, the onus then fell on the defendant to negate the evidence with an explanation of possible non-negligent causes of the injury, as per Fontaine and British Columbia. Dr. Ward's expert witnesses raised only one possible non-negligent cause, that the injury could have been caused by general inflammation to the retroperitoneum, meaning the cavity that holds the colon, due to the use of the ligature during the surgery, and that this inflammation in this area later led to necrosis and fibrosis, meaning dead tissue and scarring that spread to the ureter. However, this explanation was rejected by the trial judge, and we submit that this was for good reason. As the Ontario Court of Appeal ruled in Hassan and Anvari, a trial judge is entitled to reject non-negligent causes based on evidence. I'll go into the details of Hassan and Anvari because I think they're very relevant for this case. Hassan and Anvari is a medical negligence case where a patient's aorta was punctured by a surgeon during surgery. When the patient sued for negligence, the defense of the doctor argued that because there were other possible explanations for the injury aside from negligence, the court was not entitled to draw an inference of negligence. The two possible non-negligent causes of the injury raised by the defense were that perhaps one medical misadventure based on some unknown condition within the plaintiff's body had caused the injury and not negligence. The other explanation was that maybe some other error had occurred that was not a breach of the standard of care. However, the court ruled that because the trial judge was alive to the alternative explanations when making a decision based on evidence, the trial judge's decision could not be overturned. In Hassan and Anvari, the trial judge rejected the non-negligent explanations because the plaintiff's anatomy was normal, the sharp instrument used for the surgery was working properly, and there was some evidence that the doctor may have pushed too hard on the abdominal wall. So based on this precedent, an inference of negligence can be made even if there are possible non-negligent causes, as long as the trier of fact is alive to the alternative explanations raised at trial and then rejects them based on evidence. And this is what the trial judge did in this case. Dr. Robinette was the only expert witness who raised an alternative and potential non-negligent cause to our client's injury. The other experts disagreed that the injury could have been caused this way through inflammation of the retroperitoneum. Dr. Klotz disagreed. He said that there was no evidence of this type of injury. Dr. Bernstein disagreed, and he said that if the ligature were to cause this kind of injury, it would be a device that haunts his practice. In his words, it's not normally seen, not ever seen. Even Dr. Robinette gave this explanation based on the assumption that the respondent had stayed 5 centimeters away from the ureter. He said that this type of excessive fibrosis is not usually seen after this type of surgery. So we see that the trial judge examined this evidence and rejected the non-negligent cause based on evidence, as was his prerogative. Now, the respondent suggests that the trial judge is obliged to consider potential non-negligent causes, even if they're not raised at trial, and we disagree for two main reasons. First, defendants, as medical practitioners, are in the best position to bring forward alternative explanations and evidence for an injury. The defendant is most aware of what happened during the surgery and has prior experience and knowledge to draw on. Conversely, the patient is at a considerable disadvantage in trying to address all possible non-negligent causes, considering that they may have been unconscious during the surgery, as was the case here, and they likely do not have comparable medical knowledge. To put the onus on a plaintiff would require them to disprove endless possible alternatives and make it nearly impossible to prove medical negligence, which would bring the administration of justice into disrepute. For instance, should the appellant have raised the possibility that the ureter moved due to natural bodily functions during the surgery? We submit that to require them to do this would be illogical. She was unconscious, and any number of things could have happened in her body during the surgery of which she's not aware. However, the respondent is aware because he was conscious, And the onus should be on the respondent to raise alternatives, whether it be that the injury happened because of natural movement to the ureter, abnormal anatomy, or because of something more remote, like a fire alarm, an earthquake, or the malfunctioning of the ligature.
Counsel, I have a question for you. Isn't this the purpose of informed consent ahead of surgery, though? She probably would have, I don't know exactly what would have happened between herself and the doctor, but my impression would be that she would have gone through the risks of surgery, and she signed a document indicating that she acknowledged that sometimes accidents or things happen during surgery, and there's not really a lot you can do in an emergency situation. So doesn't this kind of go back to the fact that she acknowledged these are risks that could happen and that she shouldn't be suing for this in the first place?
Thank you, Justice. We would argue that no evidence was raised at trial that she did sign such an agreement, especially in relation to an injury to the ureter. We argue that this kind of injury is so remote that she would not have known of this risk beforehand.
Follow-up question. What steps were taken in investigating and establishing the malfunction of the actual ligature, such as a excessive sort of discharge of electricity that could have migrated closer due to the higher discharge? What steps were taken, if at all relevant?
Thank you, Justice. So in the trial judge's decision, they went over the procedure and also the notes from the surgery, this particular surgery, and there was no notes made about any malfunction of the ligature. And if there had been, then we would have expected it to be raised at trial so that it could be used in making a determination about the possibility of this being a non-negligent explanation for the injury. Thank you. So a trial judge should not be expected to rule on non-negligent causes that are not raised by evidence at trial because, as we mentioned, the patient is most aware of what happened during the surgery. And there's also a very good second reason. The trial judge, to do this would be to overstep their role as the trier of facts. It's long been established that parties to litigation are entitled to a resolution of their differences based on the issues presented in pleadings, and not to do so would be to deny either the plaintiff or the defendant the opportunity to address the issues. So this comes back to the question about the malfunctioning of the ligature that Justice Glazer just asked. If this had happened, then we would have expected the defendant to raise this at trial so that the plaintiff had the opportunity to address it. In an adversarial process, a judge is bound to make a determination on the issues on the basis of arguments and evidence before them. So to conclude on this issue of non-negligent causes, the respondent could have presented other non-negligent causes as defenses. He could have argued that if he had come closer than 2 millimeters to the ureter, he did so non-negligently. The majority suggested that perhaps the ligature came too close to the ureter because of Dr. Ward's lack of dexterity or unexpected movement within the body. However, these arguments were never made. The respondent only argued that he had not come within 5 centimeters of the ureter with the ligature. Neither Ms. Armstrong nor the trial judge have to go any further in addressing a non-negligent cause that Dr. Ward was not willing to make at trial and for which there was no evidentiary foundation. I'll turn briefly to the issue of standard of review. The respondent argues that the trial judge's decision was entitled to be reviewed for correctness by the Court of Appeal. And this argument was made on the assumption that the trial judge made an error in law related to the appropriate standard of care for a prudent surgeon. As my co-counsel said, we respectfully disagree about this position and argue that the trial judge did accurately articulate and apply the legal standard of care. Now, articulating a standard of care is a question of law reviewable for correctness. So did the trial judge accurately articulate the standard of care? If we look at the trial decision, we see that the trial judge did this. The trial judge wrote in his decision that he was looking for what a prudent surgeon should do and outlined other principles of finding a standard of care in medical negligence. The appeal court was right to review this part of the standard of care for correctness. However, after the standard was accurately laid out and it was determined that it was accurately articulated, there was no error in law, and the majority should have applied the standard of review of reasonableness to review the findings of fact made by the trial judge on what a reasonable and prudent surgeon would do and what a breach would entail. Reasonableness requires that findings of fact and inferences of fact should be given the highest degree of deference and are only reviewable for palpable and overriding error. This could include ignoring conclusive and relevant evidence, misunderstanding the evidence, or drawing erroneous conclusions from it. So for instance, if the Court of Appeal found that the trial judge ignored evidence that there were instances when a prudent surgeon might not be able to stay away from the ureter when there are no risk factors, that might be a palpable and overriding error. But as of yet, our friends have not made any direct reference to any palpable and overriding error in factual findings that would render the trial judge's decision unreasonable. Aside from the lack of error, there are also important policy reasons an appeal court should defer to trial judges on factual findings. Doing so limits the number, length, and cost of appeals. It helps promote the integrity of trial proceedings, and trial judges are in the best position to make factual findings by virtue of being immersed in the evidence, hearing oral testimony, and being familiar with the case as a whole. They also have the expertise to weigh large quantities of evidence, which is not the expertise of a court of appeal. We submit that if the appellate court had examined the trial judge's findings of fact for reasonableness, they would have found that he made reasonable findings of fact based on evidence before him at trial, and no reversible error could have been found. Justices, these are our submissions on questions of non-negligence and standard of review. In our last moments, I would like to leave you with a summary of our position and why we argue that the trial judge's decision should be restored for the plaintiff. First, the trial judge used expert evidence to properly formulate a reasonable standard of care. Second, he necessarily had to inform this analysis of whether the respondent fell below the standard of care with what he actually did during the surgery. Third, once the appellant established a prima facie case of negligence, it was on the respondent to provide convincing non-negligent explanations for the injury, which the respondent did not do. And finally, since the Court of Appeal was reviewing a question of fact, they should have deferred to the trial judge's findings since no palpable or overriding error was made. Thank you.
If there are no further questions, the court now invites counsel for the respondent to begin.
Thank you. Good morning, Justices. My name is Hiram Sutton, here on behalf of the respondent, Dr. Ward. My co-counsel is Charlotte McKenna. This appeal is about a surgeon who followed all the standard procedures of a surgery, but was still found negligent at the trial level based on an inappropriate standard of perfection. Dr. Ward performed a laparoscopic colectomy on the appellant, Miss Armstrong. When performing a colectomy, surgeons are expected to identify the ureter and try to avoid bringing their ligature device within an unsafe proximity to collateral tissue. We're here because the appellant experienced damage to her left ureter, despite the fact that Dr. Ward took the steps expected from a surgeon. Our friends believe that this result speaks to a breach of the standard of care. We submit that the standard of care when performing a colectomy is not a guarantee of success and that Dr. Ward was not negligent. Before submitting my arguments, I'd like to draw the court's attention to a few key facts that are central to our submissions. By the time of trial, Dr. Ward had performed at least 50 colectomies. He knew the standard procedures and he knew the dangers. Damage to the ureter is a documented risk of performing surgery with a ligature device. It was his practice to warn the patient of this risk. Laparoscopic surgery involves the use of a camera and magnification, which increases the difficulty of the surgery. Dr. Bernstein, one of the experts of the appellant, did not have personal experience in performing laparoscopic colectomies. And finally, no evidence was put forward that all of the documented injuries to ureters during colectomies amounted to negligence. But this appeal is about whether this colectomy amounted to negligence. There are several issues on appeal. I will be speaking to the first two issues, which fall into the category of the standard of care. These are, what is the requisite standard of care for medical negligence in Canada as correctly applied to this case? And can or ought ever causation be used as circumstantial evidence to inform standard of care? I will argue that the standard of care is performing to the standard of a reasonable surgeon, and that causation can be used as evidence, but not in this case. A third issue is raised under the standard of care. Does the plaintiff have a duty to rule out non-negligent causes? My co-counsel will speak to this issue, as well as the standard of review question. Did the majority err in applying a correctness standard of review? She will demonstrate that the plaintiff does have a duty to rule out non-negligent causes, and that the majority did not err in applying a correctness standard of review. I will be making three arguments. First, the standard of care involves identifying and trying to stay away from the ureter. Second, a finding of negligence in this case would amount to a standard of perfection. And third, causation may be used as circumstantial evidence in some cases, but not in the case at hand. My friends agree that the standard of care for professional negligence is performing with the reasonable care expected from a professional with similar training and experience. Experts were brought into trial to determine this reasonable care, and the trial judge made a finding based on that evidence. The Court of Appeal decision refers to this finding at paragraph 49. Quoting from that paragraph, the standard procedure for removing a benign colon during a colectomy is as follows: identifying the ureter through vermiculation, moving it away from the colon before proceeding, and rechecking the location of the ureter by periodically repeating the vermiculation, trying to avoid bringing the ligature within an unsafe proximity to collateral tissue. This procedure is the standard of care. The standard of care in a given situation is a question of law, as my co-counsel will go into more detail about later, but the trial judge is in the best position to make a finding on the standard of care because he saw the detailed evidence from the experts. In this case, all the experts agreed about these surgical steps. One expert, Dr. Bernstein, the appellate's expert I referred to previously, held the opinion that the ureter should never be damaged during a normal colectomy, and that if a surgeon performed all the steps I described, the risk of injury should be zero. But recall that the standard of care is performing with the care expected from a professional with similar training and experience. Without having performed a laparoscopic colectomy, Dr. Bernstein did not have similar training or experience to Dr. Ward for this specific surgery. My friends point out in their factum that the reported ureteric injuries include all colectomies, including non-ideal surgeries. We respond that these also include non-laparoscopic injuries and laparoscopic injuries, and further, that there is no evidence that every reported injury was the result of negligence. As there are documented injuries, we must accept that injury to the ureter is a risk of this type of surgery. The standard of care should simply be taking reasonable steps to avoid that injury. Having identified that the standard of care involves identifying and trying to stay away from the ureter, the question then becomes whether Dr. Ward breached that standard of care. This involves the application of facts to law, and questions of mixed fact and law are reviewable only for overriding and palpable error. In this case, the trial judge considered all the evidence before him, determined that Dr. Ward did in fact take all those steps. Such a finding should have led to a determination that Dr. Ward was not negligent, yet his liability was predicated on the finding that, despite having taken those steps, Dr. Ward did not succeed in keeping a safe distance from the ureter. Such a finding puts inappropriate weight on the result rather than the means taken to achieve that result, creating a standard of perfection. which brings me to my second argument, that a finding of negligence would create a standard of perfection.
Counsel, I'm with you with your argument, but I'm struggling with some of the evidence, particularly the evidence from Dr. Ward, in that he said he stayed 5 centimeters away from the ureter, yet the injury that we see caused to Ms. Armstrong was due to the ligature coming 2 centimeters away from the ureter. Can you help us with that?
Yes, Dr. Ward in his testimony believed that he had taken all the reasonable steps, including keeping a safe distance, which he considered to be 5 centimeters in this particular surgery that he performed. The evidence is that the injury that the appellant suffered could only happen if the ligature was to come within about 2 millimeters. I think the only way we can balance that is that at some point the ureter was off camera of the surgery. We don't have direct evidence that Dr. Ward did in fact come within 2 millimeters. So we don't have any direct evidence that he came too close. We have his testimony that he thought he was taking the reasonable steps and was staying away. And this is going to be what my co-counsel will be speaking to a little bit further, but this is one of the reasons why we don't have enough evidence to really say that he did breach that standard of care, because there's no direct evidence in front of us that says that he did in fact come within 2 millimeters.
Thank you so much, counsel. Just to follow up on that, if we don't have that evidence, then do we really have evidence that perhaps he wasn't checking and rechecking the location of the ureter as he was required to do, to be in keeping with the standard of care to be expected of him?
I take your point, Justice, and whether or not he was in fact taking those steps is a finding of fact that the trial judge did make, that based on all the evidence before him, he felt that particular step was being met by Dr. Ward, that he was checking and rechecking to the best of his ability.
So can I clarify with a follow-up question? Is there evidence, or what was the evidence of the span of time between him verifying the ureter and discharging the ligature? Can you clarify that for me?
We unfortunately don't have that many details about exactly what was happening in the surgery on this appeal. The trial judge may have had that information in front of him. Obviously, trial judges are in a better position to weigh all of the evidence and all of the facts on hand. Again, we just submit that the trial judge is in the best position to make that finding of fact, and that he did make a finding of fact that he took the reasonable steps.
Thank you.
A standard of perfection creates an absolute duty. This is the highest standard that can be applied in law. It means that the goal must be attained regardless of circumstances, and any failure to achieve the desired result invites liability every single time. In any professional setting, this would mean the standard of care is focused strictly on result. Now, in a perfect world, this may be desirable, but it does not take into account the fact that professionals are human and they make mistakes. Professional negligence accounts for this human aspect and only asks professionals to perform to the standard of a reasonable professional with similar training and experience. At paragraph 21 of our factum, we point to 2 Supreme Court cases that demonstrate that courts should look to the means to achieve a result rather than the result itself. In this case, the result was performing the colectomy without damaging the appellant's ureter. This means to achieve this result were the steps already described: identifying the ureter, moving it away from the colon, rechecking its location, and trying to avoid bringing the ligature within an unsafe proximity. The trial judge accepted that these steps were the steps a reasonable surgeon would take, and he also accepted that Dr. Ward did in fact take these steps. Unfortunately, the appellant still suffered an injury. The result is tragic and undesirable, but that doesn't justify looking to the result to determine the standard of care. If Dr. Ward took all the necessary steps to protect the appellant's ureter, but is still found negligent simply because an injury occurred despite those steps, a standard of perfection would be created. The only time a standard of perfection is appropriate is if all non-negligent causes have been ruled out. My co-counsel will be speaking to this particular issue further, but suffice it to say for now that this did not happen in this case. My third argument is that is whether causation can be used as circumstantial evidence to inform a standard of care. We submit that causation may only be used as circumstantial evidence when the standard of care cannot otherwise be established, and this is not such a circumstance. Our friends referred to two cases where causation was used to determine the standard of care. We refer to these same cases at paragraph 29 of our factum. This case is not similar to those cases. Marangolo and Osho General Hospital, for example, in that case, there were a number of potential causes that could have caused brain damage to the appellant, and whether the respondent breached the standard of care depended on what caused the damage. In this case, there aren't a number of causes that could have caused the damage, and that's not the question on appeal. The question isn't whether or not he caused the damage, it's whether or not doing so was a breach of the standard of care. The cases previously mentioned are departures from the usual practice. If the standard of care has already been made clear, there is no need to look to causation. In a usual negligence analysis, the issue of causation comes after a determination that the defendant has breached the standard of care. In other words, if a defendant has breached a standard of care, the court then considers whether he or she caused the injury or damage. So under normal circumstances, causation cannot inform a standard of care because the standard of care has already been established. As the case law referred to demonstrates, unusual circumstances may arise where causation is useful in this regard, but the standard of care in this case is not so difficult to establish that turning to causation is necessary. To conclude, Justices, our friends submit in their factum that the goal of the surgery was to avoid injuring other organs while removing the colon. We submit that the true goal of the surgery was to remove the colon, and that steps must be taken to ensure that other organs are not injured. Dr. Ward took those steps. The standard procedure was described by the experts and accepted by the trial judge. Finding liability despite that procedure being followed would establish a standard of perfection, which is inappropriate in this case. Because the standard procedure was established based on expert testimony, it is unnecessary to turn to causation to inform the standard of care. Subject to any further questions, Justices, these are my submissions. Yes.
May I ask a non-legal clarification, given the fact I'm a physician, not a lawyer? Is there any rule when the standard of care may be ambiguous or there's some doubt in terms of it being breached, such as a discrepancy between 5 millimeters and 2.5, that causation could be a secondary tool for liability?
As submitted, causation can only be used to establish the standard of care if there are multiple potential causes, only one of which would actually impact whether or not the defendant breached that standard of care. If there's some sort of discrepancy about what exactly is the standard of care, like you said, Justice, whether or not it's really 5 centimeters, 2 millimeters, or whatever that is, that's simply what the trial judge has to decide based on the expert's testimony and come to the best conclusion that he or she can. The standard of care, however, is a question of law, so a court of appeal may overturn that if found necessary.
Okay, and two very quick follow-up questions. You've used the word benign colon. I want to know how that was defined, because no one does surgery for no reason whatsoever. What did the pathology of the resected colon show? That's the first question. And the second question is, you said that consent was obtained and it was his practice. to inform of ureteric injury. Is that documented? And does he have a standard form where that was discussed? Because other evidence says that the Ms. Armstrong was not informed of that. Can you clarify for me, please?
To your first question, whether or not the colon was benign, and I take your point that nobody does surgery for no reason. The particular reason why Ms. Armstrong was coming in for surgery is not on appeal, and we don't have all of the facts in front of us. But we just know that it wasn't an unusual circumstance surrounding the surgery, such that, as my friends rightly put out, there weren't any tumors or anything making this overly complicated based on the anatomy of the specific organs. To your second question, whether or not consent was actually taken, based on the evidence that we have, we do not have those particular documents. My particular submission was that it was Dr. Ward's practice to attain that consent and inform the patient. That is something that we learned from the respondent's previous counsel in a meeting that all counsel was invited to and did have access to. But unfortunately, we do not have the records to demonstrate whether or not consent was actually attained in this case. We only know that it was his practice to inform the patient.
Thank you.
Thank you, Justices. I will now turn the time over to my co-counsel, Ms. McKenna, who will speak to non-negligent causes and the correctness standard of review.
Thank you. Good afternoon. My name is Charlotte McKenna, here on behalf of the respondent, Dr. Ward. As my co-counsel has put forward, we have been arguing that the standard of care had been determined by the experts as trying to stay away from the ureter, that the respondent should not have been held to the standard of perfection, and that causation may be used as circumstantial evidence in some cases, but not in the case at hand. I will be speaking to the next two submissions regarding the plaintiff's duty to rule out non-negligent causes and the correctness standard of review having been properly applied. First, I will be speaking to the fact that since non-negligent causes for the injury were not ruled out by the appellant or considered by the trial judge, a standard of perfection was applied, which is only appropriate when it is clear there are no other ways in which the injury could have occurred. I will then consider the standard of review that was applied. Since the standard of care was applied incorrectly and is a matter of law, the correctness standard of review was appropriate standard to apply in this case. This leads me to my first submission. My first submission is that the appellant, the plaintiff in this case, when looking to causation, had a duty to rule out non-negligent causes. Without looking to other potential causes of the injury, a standard of perfection was created. As my co-counsel indicated, the standard of perfection was not—
Sorry to interrupt. Just want to clarify one point from you before you launch into your argument. When you were saying, I guess rather the question should be, what is the onus? Who's the onus on which party to rule out non-negligent causes? Are you placing the onus on the plaintiff or on the defendant doctor?
Yes. So in this case, to rule out non-negligent causes, I'm indicating that the onus would be when bringing forward an action, it would be on the plaintiff in this case. The defendant only has the duty to rebut any sort of action that is taken against them in this case.
Thank you.
Thank you.
Counsel, follow-up question on that. I just struggle to see why it should be the plaintiff that has this onus, as they're they're not awake during the procedure. They don't have the medical expertise. I just feel like it makes more sense for it to be on the defendant. Can you help me rectify that?
Yes, thank you, Justice, for the question. So in this case, yes, you are correct. The plaintiff or the appellant in this case would have not been conscious during the procedure, so wouldn't be able to establish other non-negligent causes. However, when bringing this to trial, that is also the job of the experts in this case. So the experts that were brought forward by the appellant in this case would have needed to establish that there were no other non-negligent ways in which the injury could have occurred. For example, as my co-counsel had brought up, and I will be bringing up in my submissions, is it was not considered whether the ureter being outside the view of the microscope was considered negligent in this particular aspect. And there were no other issues in regards to how a non-negligence was, no other non-negligent causes could have been brought up in this case.
Thank you, counsel.
To continue, the standard of perfection can be used in certain cases, but only where non-negligent causes have been ruled out. Situations where non-negligent causes have been ruled out are issues such as leaving a surgical tool inside a patient and removing the wrong limb. This is at paragraph 32 of our factum. These scenarios are only possible if the surgeon had been negligent. In these instances, there is no other reason for the injury besides the surgeon's conduct. Had the surgeons in these scenarios taken the steps a reasonable surgeon would, those mistakes simply would not happen. In this case, we know that the respondent took the steps that a reasonable surgeon would when performing a colectomy, as noted by the trial judge. Yet, as we know, the injury still occurred. The trial judge established that the respondent was liable regardless of having taken the appropriate steps. Without such consideration as to whether there was a potential non-negligent cause of the injury, there was no demonstration that the respondent breached his standard of care to the appellant. It is not the defendant's duty to rule out these non-negligent causes, as indicated at paragraph 34 of our factum. A plaintiff has a duty to rule out non-negligent causes given they're the ones accusing the defendant of the negligent act, as I had previously noted. In fact, as noted by the majority court of appeal, the defendant only has the responsibility to provide a defense for the causes of action put forward by the plaintiff. The respondent must only prove that his conduct did not amount to negligence in the circumstances described. My friends note that the Ontario Court of Appeal has ruled that a trial judge is entitled to reject non-negligent causes based on evidence. We agree with this. However, the ruling out of non-negligent causes was not done in this case. To echo my co-counsel, given that both the trial judge and that the Ontario Court of Appeal identified this as factual causation, one must determine that if the standard of care was indeed breached, the next step in determining negligence is considering that the cause of that breach was only done but for that person's negligence.
Counsel,
yes.
Sorry to interrupt. Is there some type of standard or number of non-negligent other negligent causes that one is expected to raise where it becomes, we've determined that there was no other cause? Like, what is the onus on the appellant? How many other causes do they have to raise to be satisfied that there was no other negligent causes here?
Thank you for the question. In this case, given that the no non-negligent causes were put forward at all by the appellant in this case, that indicates a standard of perfection. So by doing one's due diligence and ensuring that at least you have considered potential avenues of non-negligent causes in this case, when put forward in your arguments, accusing someone of negligence, that would just be attributable to due diligence in this case, in making sure that at least non-negligent causes were considered in this case.
And just to follow up on that, isn't the fact that there are no other defendants in this action enough to show that perhaps the appellant doesn't believe that there are any other non-negligent reasons for the injury she sustained? She didn't sue anyone else. She had an opportunity to. And in fact, she ought to have if she believed that there were non-negligent causes for her injury that were not related to Dr. Ward.
Thank you for the question. Yes, so in this case in particular, the non-negligent causes, as I had iterated previously, were not ruled out. And you were correct, she had not, the appellant in this case had not brought forward any actions to other doctors in this case. However, Dr. Ward, the respondent, was the person who did perform the surgery in this case. So it's only natural that she would point after she had done the surgery that he had actually been the person who had committed the negligence in this case. However, because that no non-negligent causes were ruled out whatsoever, it leaves, the open question of whether justice was truly done in this case by the trial judge. And yes, so that's to answer your question.
Thank you, counsel.
Thank you. To continue, subsequently, it was open to the trial judge to consider non-negligent or accidental causes given the facts presented to them. In particular, Dr. Bernstein's evidence did not address why accidental but non-negligent causes could be ruled out. The facts were put before the trial judge to make such a consideration, however, no consideration was given. In addition to the standard of perfection being applied, it was also not considered if an injury occurring outside the view of the microscope, as I had previously indicated, would be considered a negligent injury. There is documentation of this kind of injury occurring. As no finding was made that the only way to obtain such an injury was through negligence, the standard of perfection was not the correct standard to apply. If the respondent is to be found negligent, it must be based on the steps he took to ensure the appellant's safety during the procedure. The steps taken by the surgery, taken in the surgery, as iterated by my co-counsel, were accepted by the trial judge that the respondent indeed took all necessary steps that a reasonable person would. Therefore, the test should have ended at the standard of care stage, and the respondent should not be found negligent in this case. This leads me to my second submission, which is that the correctness standard of review was properly applied by the majority court of appeal. It is well known that deference must be given to the trial judge when it comes to appeals. However, when the law is incorrectly applied, the Court of Appeal is able to replace the opinion of the trial judge with their own. This rule is necessary to ensure that the law is applied appropriately in similar situations that may arise and does not cause confusion on the correct application of the law. In addition, the Court of Appeal requires a broad scope of review when it comes to matters of law. The issue before us is the correct application of the standard of care. As the Court of Appeal noted, it is an error of law to use outcomes or goals as a standard of care. As my co-counsel has indicated, the standard of care was improperly applied. Was improperly applied in this case. Given that the standard of care was not applied correctly, the correctness standard review is appropriate. This gave the Court of Appeal the authority to replace the incorrect application with that of its own. The standard of care required for the surgery should not have been the goal of the surgery, but the steps taken to meet the goal. The steps were indicated by the trial judge, again, as having been followed. Nevertheless, Dr. Ward was found negligent. In addition, as noted by my co-counsel, the mistaken order of analysis regarding standard of care and causation contributed to this incorrect ruling. The Court of Appeal indicated that the standard of care was to come first before causation. Since this case was one where causation was not needed to be looked at first before standard of care, as the standard of care had already been identified in this case, the application of the law by the trial judge was incorrect. As noted in as our factum at paragraph 39, the correct inquiry to be made in assessing whether a professional committed a fault is indeed to ask whether the defendant behaved as would a reasonably prudent and diligent fellow professional in the same circumstances. We know that the standard of care was to follow a series of steps in performing the colectomy while protecting the ureter, which the respondent took. Our friends say that case law tells us that determining the standard of care is generally a mixed question of fact and law. However, in this case, the trial used the incorrect application to determine that negligence had occurred, creating a standard akin to a guarantee, which has never been law, which created this error in law. This was similarly the case in Carlson and Sutherland. In this case, the trial judge found that the patient established prima facie case of negligence based on the fact that blood vessels were inadvertently cut during the surgery. However, the British Columbia Court of Appeal ruled that this standard of care imposed on the physician amounted to a standard of perfection, which is not law. Therefore, the Court of Appeal in this case is allowed to replace the ruling, their ruling with of the trial judge. The trial judge also did not identify any steps that the respondent failed to take. This indicates that the standard of care as identified was indeed met, but improperly applied, focusing on the goal and not the steps of the surgery, again affirming that the correctness standard review was properly applied. To conclude, the standard of care in this case was met by the respondent, Dr. Ward. Through the incorrect application of the law, the trial judge unfortunately deemed him negligent. We submit that the true goal of the surgery was to remove the colon and that steps must be taken to ensure that other organs are not injured. Dr. Ward took those steps. No non-negligent causes were ruled out, and no expert stated whether the ureter being out of view of the microscope during the surgery was in fact negligent, indicating the standard of care had been met. The standard review was correctly applied in this case, given the trial judge erred in his application of the standard of care. We, the respondents, respectfully ask that the appeal be dismissed with costs. Subject to any further questions, these are my submissions.
Thank you, counsel. The court now invites the counsel for the appellant to begin their 3-minute rebuttal.
Thank you. Justices, we'd like to rebut the respondent's arguments, and we'd like to touch on 2 of the respondent counsel's submissions. First, our friends argue that the standard of care should not be a standard of perfection, as surgeons are humans and are allowed to make mistakes. When our friends say this, are they suggesting that Dr. Ward made a mistake? His evidence suggested that he did not, that he managed to stay 5 to 15 centimeters away from the ureter. Further, although our friends submit that the standard of care is a standard of perfection, this would suggest that if the patient experiences an injury, the doctor is automatically liable. One such injury includes when a doctor removes the wrong limb or leaves medical gauze in a body during surgery. In those cases, the doctor did not take the reasonable steps required of them, and the doctor found to be negligent. Here, the standard of care is not one where just because there was a bad outcome, the surgeon is found to be negligent. Instead, if there's a bad outcome, the doctor retains the opportunity to provide a non-negligent explanation for the injury. In this case, the respondent experts did provide evidence to suggest that other potential non-negligent causes resulted in the injury, but those explanations were rejected by the trial judge because of a lack of evidence and literature to support them. So this is not the case where just because the surgery happened, the doctor is found to be negligent. In addition, on the point that the respondent raised about the onus being on the plaintiff to raise non-negligent causes for the sake of due diligence, as Justice Young said, how many alternative explanations or non-negligent causes should a plaintiff have to raise? Although our friends suggest the plaintiff's expert can raise these explanations, we disagree. They are not in the room when the procedure takes place. The respondent is in the best position to present these alternatives. Second, the respondent says that the trial judge made a finding that the respondent did take all the required steps. What the decision actually says is that the respondent took steps, but went on to find that the respondent did not take the step of staying at least 1 to 2 millimeters away from the ureter while using the ligature. So he took steps, but not all the steps. As such, we submit that the trial judge did not make the findings suggested by our friends. These are our submissions for rebuttal. Thank you, justices.
Counsel, I have a question, actually, just briefly in the time allowed. Are you concerned at all that this perfection, I mean, how do we prevent a potential standard of perfection from arising from this situation? How can you ensure we're not, opening the floodgates to making, as you said, a standard of perfection here and making doctors unnecessarily liable in certain cases?
Right. So I suppose the standard of care would be applied to surgeons who are performing this particular surgery where there are no risk factors, where the colon is benign. And so to avoid this being a standard of perfection, we submit that there are opportunities to raise non-negligent causes, and that the only reason this wasn't done in this case was that the respondent at trial refused to admit that he could have come or he did come within 5 centimeters as the evidence, the direct and circumstantial evidence suggested. So in another situation, the respondent might be willing to make this kind of argument, and then those alternatives would be raised.
Thank you, counsel.
Thank you, counsel, and thank you, justices. This concludes the matter of Armstrong and Ward. I invite you to stay in this session. Feel free to watch the next one. It'll begin at 11:30. But besides that, thank you all for your time.
Thank you.